The Supreme Court is speaking, and they're speaking on everything in front of them right now. You've got the mag ban case out of Rhode Island, you've got the semi-auto ban out of Maryland, and you have the lawsuit of Mexico trying to sue gun manufacturers here in the United States. Let's talk about them all. Hey everybody, welcome back to the channel today. The Supreme Court has finally spoken, not necessarily in the way that we would have wanted, but they are speaking nonetheless. We also had an opinion drop recently. That, of course, is the Mexico versus firearms manufacturers lawsuit. So to walk us through all of this, we have brought back the CRPA president. That is Chuck Michel. Chuck, thanks for being with us today.
Oh, it was a pleasure, fellas. Thanks for having me.
Absolutely. And guys, before we get into this today, please be sure to like, share, and subscribe to these videos. Throw a comment down in the comment section below. Ask us your questions on this. We want to get information on these out as far and wide as possible, and certainly all of that is beneficial. So Chuck, let's jump right into this. I wanted to start with the Mexico versus U.S. firearms manufacturers lawsuit first. I would normally ask you to summarize, but they actually summarized it in the syllabus on the opinion on the SCOTUS website. So I thought, Jacob, if you could just throw this up, it summarizes the lawsuit very well, and it reads like this. Here, the government of Mexico sued 7 American gun manufacturers, alleging that the companies aided and abetted unlawful gun sales that routed firearms to Mexico drug cartels. The basic theory of this lawsuit is that the defendants failed to exercise reasonable care to prevent trafficking of their guns into Mexico, and so are responsible for the harms arising there from weapons misuse. That theory implicates PLCAA's general prohibition, so the complaint tries to plead its way into the predicate exception. It alleges that the manufacturers were willful accessories in unlawful gun sales by retail gun dealers, which in turn enables Mexican criminals to acquire guns. And it sets out 3 kinds of allegations relating to how manufacturers aided and abetted retailers' unlawful sales. The manufacturers allegedly, 1, supplied firearms to retail dealers whom they knowingly, illegally sell to Mexican gun traffickers. 2, have failed to impose the kind of controls on their distribution networks that would prevent illegal sales to Mexican traffickers. And 3, make design and marketing decisions intended to stimulate cartel members' demand for their products. The district court dismissed the complaint, but the First Circuit reversed, finding Mexico had plausibly alleged the defendants aided and abetted illegal firearms sales. Because Mexico's complaint does not plausibly allege, okay, and this is now getting into the Supreme Court decision. Because Mexico's complaint does not plausibly allege the defendant gun manufacturers aided and abetted gun dealers' unlawful sales of firearms to Mexican traffickers, PLCAA bars the lawsuit. So, Chuck, I guess, first of all, really quick, if you could definitionally, what is the PLCAA and why is it that this lawsuit is running into it?
Okay, so it's the Protection of Lawful Commerce in Arms Act, and it was passed, I want to say, probably 20 years ago, because all the municipalities, anti-gun owner municipalities, were getting together behind the Brady Center and the Bloomberg groups and suing gun manufacturers for the criminal misuse of their products on some stretched out theories of liability, like creating a nuisance or they got very creative because they had a lot of lawyers getting paid by Bloomberg to come up with creative arguments. But the goal was clear. It was to bankrupt the firearms industry. And they didn't really make much of a secret about that. I got to remember, firearms industry makes in a year what the tobacco industry makes in a day. So it's not a big industry. It doesn't have the deep pockets that many larger industries have. And the gun ban lobby knew that. That's why they wanted to sue them. And they filed like 20 lawsuits across the country alleging that the manufacturers were putting guns into the hands of criminals and where they were being misused. And they were blaming the gun makers for that. They did some famous stuff like one firearm had an ad that said it's fingerprint resistant, which of course means, you don't get the corrosion from the moisture in your fingertips when you're holding a gun if you don't wipe it off right. I mean, that was a a selling point, and they turned that into, oh, you're talking about criminals not leaving fingerprints on the gun. I mean, the distortions were just out of control, but they were getting some traction. And even if they didn't win a case, they could cause a gun maker to have to spend millions of dollars. So the Protection of Lawful Commerce and Arms Act was put into place to stop those lawsuits. But there's a couple of minor workarounds that the gun ban lobby started looking at ways to exploit. One of which is if the gun is used illegally. And so Mexico decided to try and sue the gun industry again, blaming the manufacturers for guns getting into Mexico across the border illegally, and then being illegally used by cartels. So thankfully, and they've been trying to do that lately in several cases where they've managed to get cases around the Protection of Lawful Commerce and Arms Act and try and hold manufacturers liable. I think Bushmaster in Connecticut was the most recent example of that. But so this decision points out that, holds that, and it's 9-0, holds that you can't just speculate about what manufacturers may have known, what they may have done, why people were buying guns illegally, how people were illegally using guns, and then try and hold the manufacturer liable for the criminal misuse of its product.
Well, yeah, and there's certainly firearms. The firearms industry isn't the only place that has protections for manufacturers like this. You have laws for tons of things. The obvious one, the first one that's going to come to mind is the car industry. There are protections in place for manufacturers when things happen or people use vehicles to do the wrong thing. So not necessarily unheard of as far as the PLCAA is concerned. And that ended up being the main roadblock for this lawsuit for Mexico is concerned, which stated plainly there, the Supreme Court says that is the ultimate roadblock for the lawsuit. So they went ahead and dismissed it. I'm sort of curious though. What are your thoughts? You kind of mentioned the firearms manufacturers back then when the PLCAA was originally put in place. Is the manufacturing industry in a different place now? I guess what I'm curious about is how damaging would this lawsuit have been had it gone the other way? How much would it have affected the Second Amendment community?
Well, it would have affected the Second Amendment community because the manufacturers would have had to spend a lot more money defending themselves against claims that they're responsible for the criminal misuse of their products. And that would have been translated. Some manufacturers likely would have gone out of business, and others would have had to pass those costs along to us. So the gun buying community. So as gun buyers and gun owners, this helps us because we will have access to more choices for firearms appropriate for our individualized use. And the price won't have to factor in millions of dollars for attorney's fees to defend against frivolous lawsuits.
Right. So, So I guess the effect there is that some manufacturers, the smaller ones, probably would have gone out of business, and then you have more being put on the consumer in the end for those manufacturers to survive. So definitely an important lawsuit for the manufacturers to have won here. That doesn't just affect them, that affects the community as a whole. Let's go ahead and close the page on this. Just a final question. The Supreme Court dismisses this. Well, they send it back to the First Circuit and say, apply this. Is this effectively the end of this lawsuit, them having decided that the PLCAA stands taller than the lawsuit itself?
Yes. For Mexico is out of luck, or out of court, as they should be. But there's a little Easter egg in here. There's a little jewel in here.
I think I found that Easter egg as well. That was the next question I was going to ask you. Actually, Jacob, since we're on this now, can you just go ahead and pull it up? Chuck, let me read this really quick, and then I wanted to ask you about it because I think this can be important. It's from the opinion as well, and it reads like this. Finally, Mexico's allegations about the manufacturer's design and marketing decision add nothing of consequence. As noted above, Mexico here focuses on the manufacturer's production of military-style assault weapons, among which it included AR-15 rifles, AK-47 rifles, and 50 caliber sniper rifles. But, and here's the nugget, those products are both widely legally those products are both widely legal and bought by many ordinary consumers. So go ahead and put your big period there. I know that the opinion was largely talking about the PLCAA. This certainly seems to be a nugget, though. Is this an argument for in common use for these semi-automatic rifles?
Well, it's a rebuttal. It's striking down some of the arguments that the gun ban lobby continues to make in cases where we're challenging AR-15 bans or semi-auto bans or magazine bans or whatever. They falsely label the AR-15 as a quote unquote military style assault weapon, even though they're semi-automatic, and never mind that fully automatic is not necessarily military style either. But there's nothing that says that you can't have military style firearms, but the ARs are generally not they're generally not military style. They're not select fire, if that's the test. But they also talk about 50 caliber, which is typically a bolt action. What the Supreme Court has done here is said, no, that when they're in common use, first of all, it doesn't matter if they're exclusively for self-defense. They can still be protected by the Second Amendment if they're in common use. And it doesn't, no matter if it's for target shooting or any other lawful purpose, not just self-defense. The gun ban lobby tries to argue that Heller and Bruin only cover firearms that are primarily in common use for self-defense. They ignore hunting, they ignore sport shooting, they ignore marksmanship. But what they're saying here, and they're citing they also try and claim that AR-15s are not in common use, even though they're the most common, as the Supreme Court cites the source, how the AR-15 became the best-selling rifle in the United States. There's plenty of evidence, plenty of factual support that AR-15s are the most common firearm in the country because they're the most versatile. It's a modern sporting firearm. Everybody wants to buy them. The point is, though, the Supreme Court is saying it in this opinion, and we already put that in our brief that's going into Illinois today to the Seventh Circuit's Court of Appeals in Illinois over their semi-auto ban, because they're making the same arguments in the Illinois case that they make in the Ninth Circuit, in California cases, in New York, and the Second Circuit in the New York and New Jersey cases. I mean, this is a huge little gem that can be mined from this case that really primarily dealt with the Protection of Lawful Commerce and Arms Act and how far it applies.
Well, my next question was going to be, if that nugget meets the standard of, precedent that you want to use for other cases. Obviously, you've made that clear. So, I mean, we've got two really good things coming out of one case here. What we just explained with the AR-15s that can be used in other semi-automatic ban lawsuits, and you've also got the PLCAA standing up against the muster. So definitely some good news there. Let's transition here really quick, Chuck, to some not so good news. We've been watching the Ocean State Tactical case, which was the sensitive places case out of Rhode Island that has continued to be passed on by the Supreme Court for months. You've got the Snoke case, which is the semi-auto ban out of Maryland that also has been passed on by the Supreme Court for the last several months. The Supreme Court finally came out. They denied cert for both of these lawsuits. I guess just general, I have a couple of quotes here that I thought are interesting, going back from Kavanaugh and Justice Thomas on the Snoke case, but just in general, what direction do you see this taking now that these two cases have been denied for the Supreme Court?
They're going to take another case. They just didn't take these cases, and it's hard to say why. In Rhode Island, the magazine capacity test case might be because it was a preliminary injunction appeal. It wasn't a final judgment. In Snopes, the Maryland semi-auto ban, That law is a little weird. It's not as extreme as some auto bans. That might have something to do with it, but it also might just have to do the, remember they had three judges dissent: Thomas, Alito, and Gorsuch. And it takes 4 votes to take a case, 5 votes to win one. If they'd had another dissent, they would have had the 4 votes. So Kavanaugh did not dissent, but he issued a statement, and in that he said, we need to take one of these cases. We'll take it in the next term or two, basically saying we're busy with this Trump stuff right now and all these emergency appeals. So we don't have time for this case right now. That may be part of the reason. Another part might be because so-called assault weapons have this emotional baggage and this political heat that comes along with those guns because of the fact that the gun ban lobby has successfully created a false narrative in the minds of many people about what a quote unquote assault weapon is and how they're used and what legitimate uses they do and don't have. So they may have wanted to just avoid that, the politics of that. But that doesn't stop us. We'll be filing the Duncan petition for cert in the Supreme Court next week. And we have others queued up as well. I mean, the court, it's pretty obvious from the dissents and from Kavanaugh's statement, and then from the language in the Smith and Wesson versus Mexico v. Smith and Wesson case, that's Justice Kagan, that a lot of these arguments that the other side is making are going to be tossed out. We're right, and the court agrees with us on common use and semi-autos being in common use and the whole methodology of Bruin, where what does the right to keep and bear arms, that phrase, what does it cover? It's not just hardware, it's all the conduct associated with it, going to a range, getting a gun fixed, going hunting, all that stuff is covered by the Second Amendment. And they try and say that military arms, whatever that is, they'll define everything as military. And then they'll say military arms are not even the type of arms that are covered by the language of the Second Amendment itself. So all of that is being rejected by the Supreme Court, but not in a case that is binding precedent. It's in these dissents and in this language in the Mexico case. So, but it's all great. They're telegraphing that we're going to win. When they finally take a case, we're going to win. So it's just a matter of time, and we have to keep trying. There are multiple challenges to semi-auto bans going on in multiple jurisdictions across the country right now. Every one of them is queued up for a Supreme Court review.
Well, you may have already alluded to this, and you guys, Jacob may have had to throw an edit. I think I said the Ocean State Tactical case was a sensitive places case. Of course, that is a mag ban case out of Rhode Island there, but it was a mag ban case that was up on interlocutory appeal, wondering if that may have been the reason for not taking it. In the sentiment of what's going on with Trump and Musk right now, they're definitely feuding. I kind of wanted to ask you, Jacob, if you could throw this up. Reading the statement by Kavanaugh and then the dissent by Thomas back to back, it kind of seems like there's definitely a difference in opinion here. From Kavanaugh's statement, Jacob, if you could pull this one up, it says this. In short, under the court's precedents, the Fourth Circuit's decision is questionable, although the court today denies certiorari. The denial of certiorari does not mean that the court agrees with the lower court decision or that the issue is not worthy of review. The AR-15 issue is recently decided by the First Circuit and is currently being considered by several other court of appeals. Opinions from other courts of appeals should assist this court's ultimate decision-making on the AR-15 issue. Additional petitions for certiorari will likely be before this court shortly, and in my view, the court should and presumably will address the AR-15 issue soon, in the next term or two. And then it seems like Justice Thomas's dissent contradicts that directly. This is from Thomas's dissent. I would not wait to decide whether the government can ban the most popular rifle in America. The question is of critical importance to tens of millions of law-abiding AR-15 owners throughout the country. We have avoided deciding it for a full decade and further percolation is of little value when lower courts in the jurisdictions that ban AR-15 appear bent on distorting this court's Second Amendment precedents. I doubt we would sit idly by if a lower court were to subvert our precedents involving any other constitutional right. Until we are vigilant in enforcing it, the right to bear arms will remain a second-class right. If you guys remember, he said the exact same thing in the Bruin decision. So Kavanaugh basically says, let's wait and see. And Justice even though Kavanaugh went on to say, like you said earlier, all of the things he's telegraphing that he wants to provide the right opinion, but he doesn't want to do it right now. Justice Thomas comes out and says, to hell with waiting. Why do we have to wait? This stuff has been talked about for a decade. AR-15s are being banned. We need to act on this now. And until we start treating cases like these like other cases that have to do with constitutional rights, the Second Amendment will remain a second-class right. I mean, it's hard. It's hard not to agree with both because both want to give the correct answer. But what's your take on this, Chuck? You alluded to the fact that there's a bunch of Trump stuff going on right now. Can they really not handle it?
They could handle it. They could handle it. There's something going on behind the scenes. Everybody knows they got to take one. Kavanaugh is paying lip service. This whole, we need to let it percolate some more. That's typically the Supreme Court's that's why they hold off. They want the body of law to be developed in the lower courts, but this body of law is already developed, and the jurisdictions that want to uphold AR-15 bans just steal the language from the other court's ruling and adopt the same test. They're all doing everything the same way wrong, and so they bootstrap the step one of the Second Amendment analysis about whether or not it's covered by the right to keep and bear arms. They toy around with what arms means, and then they distort the degree of historical analog that will justify a modern day law. They'll use a Bowie knife law to justify a modern day assault weapon so-called law. So it's the same game. There's no need for any more percolation. So something else is going on that's holding the court off, which I think might be they're just overwhelmed. But they have plenty of, this wouldn't have been heard until next session anyway. So, it would have been after October anyway. So, because they're about to wrap up for the year. So I suspect it might be that there's some hesitancy, some nervousness about wading into the so-called assault weapon issue. And that's why CRPA's Duncan case is a better case because it's a magazine. It's not as emotion laden and
well, that's sort of my next question to you. Kavanaugh talks specifically about the AR-15 issue. When we look at cases like this, we look for precedent for, I guess, more broadly scoped, statements to provide good outcomes in other lawsuits as well. Can a case like the Duncan case end up being what we've been talking about and also provide something specifically for ARs?
Yes, because it clarifies the methodology. Once the court says that arms include magazines, then they can include suppressors. They include semi-automatic AR-15s, even if they were characterized as military style, which is baloney to begin with, but they will include military. It's anything you can carry. Arms, fully automatic are arms too. It's a matter of whether or not you can regulate them. The arms is a very broad term. Once that's clarified, no matter what case it's clarified in, it straightens out the analysis in all the cases. So Duncan could absolutely, or any other case that's not an AR-15 case, that forces the court to clarify the Bruin analysis and how it applies, is going to help in AR-15 cases and every other kind of case.
That doesn't necessarily mean that it doesn't sting to see these two lawsuits get denied cert, but certainly A lot more to look forward to. You're kind of laying my schedule out for me right now. We're gonna have you on next week. If cert for Duncan is gonna end up getting filed, let's go ahead and go through that one. I guess, Chuck, just as a big picture to close this out, you got 2 denials here, but you also have a victory for manufacturers in the Second Amendment community with the Mexico lawsuit. What's the overall thought here? I mean, even in the 2 denials, you have a telegraph of victories in the future, right? So what's the overall thought from these 3 lawsuits, and what's the thought moving forward?
Well, the fight right now is Illinois. We're filing our brief today. We won in the trial court twice again. And so we're now in the Seventh Circuit, and we have to deal with again, they sort of bastardized the Bruin test. So we have to deal with their wrongful methodology. But this language helps. And then the Illinois case may be the one that it will be if we lose in the Seventh Circuit. Well, if we lose in the Seventh Circuit, we will definitely be asking the Supreme Court for review come October, November, December, whenever this decision comes down for the Seventh Circuit. So the fight goes on. The fight goes on. This is a historical time for the Second Amendment. We will win eventually. All the signs indicate that we are doing it right. We are arguing it right. The other side is twisting things and benefiting from from biased courts. And so folks need to support CRPA, support the efforts that we're making in court, and be a part of that history as we develop it and enhance and protect freedom for our generation and for the generations that are going to come after us.
Yeah, and certainly if Duncan ends up getting granted cert, that could be national history that it ends up making, just like the Bruin decision. So very important, and it could all be happening throughout CRPA's 150th anniversary year. Guys, check out the store. Jacob, can you drop a link for the shop? I know that we put the links to these opinions and all of that stuff so that people can read them themselves. Guys, if you're not already, become a member of CRPA. We have been fighting this fight for 150 years. We're going to fight for another 150. Definitely a good time to be an advocate for the Second Amendment. But Chuck, I know you're a busy guy. Look forward to having you on in the future, but thanks for coming on and sharing today.
Sounds like we'll be talking next week, fellas. Thanks for having me.
Indeed, and absolutely. Thank you very much. And guys, if you like videos like this, you want to continue to see the content, you want to continue to see the fight move forward. We're fighting in every corner of California and beyond. Go ahead and like, share, and subscribe to these videos. It really helps get the information out there. We're trying to get everybody on the same platform so that we can advocate effectively, which we currently are and want to continue to do throughout the year. So go ahead and do that. Drop comments below. It really helps the algorithms as well. Thanks again, guys. We'll see you on the next one.